afternoon, all ladies and gentlemen. I've just um, I've just got to share this video. I've just spoke to Wayne Leighton, the famous Wayne Leighton, who's going to the High Court about the legality of council tax enforcement. Without further ado, I'll play the video. Make sure you like and subscribe to him, and Sonia as well, and myself if you could. It would be much appreciated. And yeah, I'll play you the video. Watch it. This is a cracker. This geezer's a fucking legend. See you later.
I am going to bring in my first guest. Let's bring him in because this is actually such an important story. Such an important story. Let's bring him in. There he is. Good morning, Wayne. How are you?
I'm good, Sonia. How are you?
Great to have you with us, everybody. This is Wayne Leighton. You might not have seen Wayne before. I think this is one of Wayne's first interviews, and I'm very honoured to be able to do that. And Wayne has been mentioned on our show before. Wayne has a precedent-setting High Court judgment in his favour. And Wayne, prior to you coming on today, I went back through your judgment last night, and it is a beaut to read, isn't it, in so many respects. And I think it's important just to briefly reflect on that judgment, because that's obviously what's brought you here today and where you are heading back into the High Court. So let's just talk a little bit about you. You are an activist, but you're an activist who makes sure that things get done. You're a litigant. You're a litigant in person. Sovereign Pete was on our show the other week talking about your unprecedented work. You have a case management set for the 13th of May, 2025, and you want to get as many people together to support you as possible. So let us just briefly look at that judgment from before. And it is actually, as somebody who receives quite a lot of judgments, because I'm in a High Court case, that must have been so wonderful for you to read. And I'm going to read a particular line, and that is, in conclusion, in summary, I am satisfied that the claimant, which is Wayne, has established a breach of paragraph 26 of the schedule in that the defendants failed to provide evidence of their authority. That was an enforcement agency. You took an enforcement agency to court and you proved that they had no authority over you. That was stunning. Wayne, talk to us a little bit about that judgment.
Well, they still haven't established what authority they've got now, and that's the big issue. They're still bullying people nationwide without any authority. My biggest takeaway from that judgment is actually paragraph 4, where at the end he said this situation is ripe for reform. So the High Court actually said the whole system's ripe for reform. It's not just this enforcement agency, it's all enforcement agencies, and it's the actual procedure that leads to them doing what they're doing. So it's a major problem, but it's the whole system in general. It's not just enforcement agencies, it's the enforcement of council tax. It's just abused in many ways. Now, if you ask an enforcement agent to show their authority, they all have different answers, and this is the big discrepancy, because they don't have the authority at the moment, the source of it, to establish their authority, what they're doing. So I'll give you some examples. If you ask Dukes or Hanbury, they'll still use the council letter of authority, which you just referred to in the judgment, where they say they're not allowed to use that. If you ask Equator, they say to you they use a notice of enforcement, which again was dismissed in the court. They said that doesn't confer authority, it restricts it. Bristow and Sutter, now they're just issuing fake pieces of paper. Excel, they'll give you council extracts. Rundles, they're a joke. They say that their ID, the certified agent ID, is their authority to come into your premises. Newlands, they just give you a template. They say you're making freedom of the land claims when you're asking for their authority under their legislation. Jacobs and Ross and Roberts, who are owned by the same company, they'll use the Coffer judgment, which was somebody who took a case to the High Court. She was ill-advised with bad advice, and it was dismissed on the basis of, well, permission wasn't refused on the basis they then exhausted all remedies. But they use that as a diversion tactic. And then you've got Marston's, who they say, oh, we don't have to give you a deed of assignment, but the deed of assignment has got absolutely nothing to do with their authority to come into your premises. So people say to me, well, how are they getting away with still doing this after what the High Court said, which you just cited? And the fundamental reason is that these companies are private limited companies. They trade for profit. Yeah, that's what they do, right? And Bristow and Sutter in general, like they've got two companies. They've got Bristow and Sutter and Bristow and Sutter Limited. And last year, like, if you look at their accounts, they took £30 million off the public for what they're doing. Now, I got 4,000 compensation and 7 in costs, which for my own time. So if you think if they've had 11,000 that they had to pay me and they're making 30 million a year, it doesn't really give them much of a deterrent factor to stop doing what they're doing. So they've just ploughed on regardless, and the situation's not changed, even though what the High Court have said. And we're seeing situations where at the moment where the clamping cars which have blue badge on. I mean, I've dealt with hundreds of cases where I've been helping people.
Let me just stop you there, because I want to come to that. I want to come to all of that, all really, really good stuff. I just want to let people know that you were actually awarded costs on this judgment, right? It was Wayne Leighton versus Bristow and Sutter, which is obviously the enforcement agent, and the judge awarded you 4,000 costs, which absolutely clarified that you had won this unquestionably. And as I say, it has been used repeatedly, and so now you're back in the High Court. Right, you're going for a case management conference. So, but before we get there, let's briefly go back, right? What brought you into this arena? You were helping a friend, weren't you?
Yeah. So initially, what got me into all this, I was helping a friend, but it wasn't to do with bailiff abuse of power. It was to do with police abuse of power. And they were going to his house because there was an investigation. There was some copper wire going missing from a derelict building. And some of the people identified lived at my friend's house. So they were going to his house and they were searching for it. And they were seizing property of any value, right? And they took his dad's sentimental items in his dad, because his dad was deceased. So he was very sentimental. And, obviously I was new to all that back in 2012, but I knew there was something wrong. So I made and there was no warrants as well. That was the other suspicious thing. So I made a complaint to get his property back and to see the warrants. Now, I was expecting them actually to take the complaint seriously, and that was when I was first introduced to the world of cover-up. And so they dismissed the complaint and didn't even return his dad's sentimental items, and they didn't provide the warrants. I'm like, well, hold on a minute. If you've got nothing to hide, you would give the warrants and you would give the property back. So I've appealed to the IPCC, which has now changed its name to the IOPC, and I thought, independent organisation, get some recourse. Well, they're just as corrupt as I can say that because I can prove the court proceedings. So and so they didn't do their job. So I took on behalf of my friend the IOPC to the High Court. Now the High Court quashed their decision as irrational, and they had to now take a new decision. And then the IOP's new decision was to order the police to hand over the warrants. Now, the police knew that they didn't have the warrants to hand over, and they didn't want to admit that. So they thought they came up with a strategy. Well, if we get Wayne out of the way, his friend can't pursue this. So then they started targeting me. So then this became a personal thing. I was just helping a friend out at first, and then I came under attack. And at first it was more minor stuff. They'd just come to my house and try and pressurize me for a signature to close the complaint, pull me over at work, send me requisitions. Just to clarify what a requisition is, the police for minor offences can charge you and summon you to court without any authorization from the CPS or from the court. And to get around that, they don't issue you a summons, they issue a requisition, because a summons has to have a judicial function, but a requisition isn't. Now, I was getting a letter from the police about the complaint, and in the same post there was requisitions. They're basically saying, look, you're being prosecuted for continuing this complaint. So this went on for a while, and they were putting their investigation in the background while they were trying to intimidate me to stop pursuing this complaint. And this went on for a while, and then when they realized that these intimidation tactics weren't working, they stepped it up a level, and they made an undercover operation against me. And they did this to find out all my habits, to learn everything about me, find any bad habits they can to discredit me. And I won't go into how I found that out, because that'll ruin the storyline of my book that's coming out. But
we don't want to do that.
it goes really, really deep, that, and it went on for years. And, you know, to cut that very, very long story short, in 2018, 6 years after I made the complaint, so I made the complaint about that in 2012, they said, when I finally forced them to give an answer, because of the lapse of time, we've lost all the warrants. Okay? All 9 of them. Yeah. Well, there was many things were wrong, because I could show from documentation there was actually 11 entries. Also, I contacted the court, and some of the dates they said the warrants were issued. They said there was no warrants for anyone issued that day. And there was multiple things, like you're supposed to keep digital records. When it's a complaint, you have to preserve the evidence. There's so many things. Right?
You've been so thorough, and that's how you've caught them, though, Wayne. That's the thing, is that in my first conversation with you, I was like, this guy is forensic. I don't know how your brain works exactly, right? But you've taught yourself, you know, all the legalities of it, and it's absolutely brilliant. I absolutely love it. You sent me 2 videos. What the police enforcement one? What do you want me to play that in regard to? Because I'll play them whenever you want to.
Yeah, well, that one, I'm just coming on to that now. So I had a deep understanding of powers of entry from that case, right? And then because of that deep understanding, when I've got Bristow and Sutter coming saying they're going to come into my property, and then challenging their authority to come into my property. And this is how, you know, it went to the High Court. They said their source of authority was the council. It proved that the council don't have that authority to authorise. And still, they still to this day have not answered the question of where did they get their source of authority from. Ooh. And so now we're in a situation where they're still doing the same. Now, this next video I'm going to show you, the one with the police, what they're doing here is they have a warrant. They're executing a warrant. It's a council tax one, right, for not turning up for a hearing for a means test for committal. And I'm just going to show you, after you've played the video, I'll just give a brief summary of it to show you some of the problems that we're facing with this. So if you could put that police one on, the one where they enter before, we're going to enter by force.
Let's do it.
That's so unfortunate. Sally, we believe you are in the property. If you don't answer the door, we will get other officers to come and force entry.
But what you've got an outstanding warrant, and I know you've got issues with the courts and stuff like that.
We've explained it, yeah. It's a council tax.
Yeah,
it's not anymore, because I think, Sally, like we said to you yesterday, that you were supposed to rent.
Don't break the door in. You don't need to break the door in.
Right, Sally.
Right, just you don't need to.
Sally, look, we have been really reasonable with you. We had a right, we had a good time yesterday.
should we? 3 of them. What does it say? I, Sally Nicholson, have Warrant.
Right. That would be a nightmare, obviously, to be on the receiving end of that. Talk to us, Wayne.
That's just for council tax, right? Now, they were exercising what's called a Category C warrant, right? Now, there's different rules of execution for different types of Category Cs, but the police there did not realise what type of warrant they were executing. So if the police themselves don't know the different types of warrant, how do the members of the public know what their rights are on the different types of warrant? And this is causing a big confusion and a big problem. Now, so referring to actual enforcement agents, right, they're claiming they don't need any warrants, and yet the only other mode of enforcement have been a writ or a warrant. So, for example, if you get a county court judgment, the judgment is one instrument, but then the warrant is a second instrument. Same with the High Court. High Court judgment is one instrument, the writ is another instrument. Same with the magistrates. Say a fine, that's one instrument, and then the warrant is another instrument. Well, they're saying that once a liability order is made, they don't need any more instruments. That's it. They can just come straight into your property. So what they're in essence saying is, say for example, a single mother who's, say she's got 3 children and she's not refusing to pay council tax, she just can't afford it, she's struggling, right? They're saying that in her situation, if she can't afford to pay it, then they can come straight in. But criminals who are causing harm, they get protection of a warrant. People in civil cases who are ripping people off, they get protection of a warrant. You know, well, how does that, you know, what's your source to say that people in them vulnerable situations don't get the protection? So they're manipulating it, and we're seeing so many abuses, you know, going into people's houses with no authority, clamping cars for, you know, people who need them to go to hospital, blue badge cars, and saying you need £110 to take the clamp off when you're not even allowed to put the clamp on in the first place, threatening vulnerable people. One case, there was an enforcement agent who wasn't certified, and when they were challenged, they said, oh, well, he was in the presence of someone who was certified, but on the video, he was by himself. So you've not only got them abusing powers, but you've got them lying to cover up their actions. And, you know, this isn't just one agency, it's all of them enforcing council tax. And there's fundamentally no protection at the moment. And they've not been able to answer is, where do they get their authority to come into our premises and do that? And that's one of the big questions in the new court case. There's 3 questions to answer, but that's fundamentally one of them. Now, another issue I want to touch on, which is just as important, if not more important, but it's not as common, is them sending you to prison for not paying council tax.
Right, that's the next video, right?
Yeah. Just before we get onto that, now some people think because it's civil you can't go to prison. But the right in the assumption it's civil, not paying council tax is never criminal, right? It's always a civil matter. But you can go to prison as a civil prisoner, and I've helped various people with this. Not as much as the bailiffs, I've helped hundreds of them, but with the actual committals, I've helped several people, and every case I've helped, they've not followed due process. They just don't follow it. And I'm finding cases where they're lying to people, because what the council are doing, in some cases, to get a summons for a liability order is very different to get a summons for a committal, because the summons for a liability order is done in bulk, like maybe 3,000 people at once in some cases. But a committal, it has to be individual. And what the councils are doing, they're lying to you by saying there's a committal warrant, right? And there isn't actually any committal warrant being issued. It's just a bulk liability hearing, and they're confusing the two to try scare you into paying.
Whoa!
So this is, and I can prove this. And it's not just one council. I've caught a few councils doing this, right? They lie to you because a committal warrant summons is expensive, and rather than paying it, they pretend they've had it issued. And if you ask the court, they'll have to tell you if it's a committal warrant. Not a liability order hearing, a committal hearing. So you best ask the court, has the one been issued? Because they are lying to people.
Oh my God. So, you should be, do you do courses, Wayne? This is literally course-worthy stuff. I would sign up for a course like this.
Well, you know,
Wayne's got enough on his plate. He's dealing with the high court.
No, it's not that.
This is what I like about you, though. This is what I like about you, is you didn't immediately seek to monetize anything. You were like, I want to do the job. I just want to do the job. I don't want fame. I don't want attention. I know you haven't. That's what I like about you, mate. I like it.
Yeah,
I'm
all about remedy. I'm not trying to boast or gloat. Say, oh, look at this. I just want to make change for the good.
You do.
And so I've been so focused on targeting the people who are doing this, rather than just making videos, you know. But obviously now it's to a stage where this new case is going to fundamentally change everything if it's successful. So it's important to now get some information out there. So, you know, with that scam I was just talking about, there's one of my friends, Danny, he actually got somebody out of prison for non-payment of council tax. He did a really good job, and I'd just like to show that video for what he did for her.
Let's do it.
So
that's Carla Buckle, right?
Yeah.
Let's do it.
Who Carla is?
Not off the top of my head.
Okay, she was jailed yesterday.
Right.
For 8 weeks.
Right.
For non-payment of council tax.
Right.
By your council.
I cannot speak to you about this.
No, I'm not asking to speak to you, Dave. I'm asking to speak to the lawyers that you're speaking to.
Without authority to act from Carla, then we will not be able to speak to yourself.
Well, you can't get authority from her because you put her in jail yesterday.
Yeah,
And we're going to see her in jail tomorrow to get that authority.
No, it's not a matter of speaking to lawyers. We cannot speak to you without the authority, and I'm going to end the call, I'm afraid.
You are, Dave, are you? You are you? But why is that, Dave?
Because I've explained to you already.
You have not explained anything. What is the name of the person I need to speak to?
You spoke to somebody earlier.
I spoke to Dave, who put the phone down on me. Yeah, because I was asking him questions he didn't want to answer. But he's obliged to because he's a public servant. It's amazing, isn't it? So we're talking to the council tax department and they say, oh, you can't speak to any lawyers because they're not involved with this.
Well, that's right.
Well, that's wrong. It may be right, but that's wrong. This woman is in jail.
Is this regarding Miss Buckle?
It is actually, yes. I'm trying to, I've just had the great news that the High Court have decided to release her. And that's why I'm phoning, because I wanted to let you know that some of her family and friends are coming down there now, in the next hour or so that they're there for her when she gets released.
Love that line. Carla did manage to spend Christmas with her grandchildren. We need more characters like you, like your mate. As people are saying in the comments right now, we've got too many Daves, right? And they prop up the system. They act as a buffer to the system while continuing to frustrate us all. But your mate did a brilliant job with Carla. Talk to
Danny,
us, Wayne.
Amazing, Danny, yeah.
Danny,
yeah,
all props to Danny.
Yeah, amazing guy. So the cases I've been in with committals, they've not gone to prison because the procedure's not been followed. And again, it wasn't in her case, but she'd already gone to prison before Danny got involved, and that's why he got her out. But it's really quite controversial that the councils are trying to send their constituents to prison when we've got the Labour government who are releasing criminals from prison early because they're overcrowded.
Right.
It's like, you know, it's a real contradiction there how they're using the system. And so now we're going to get onto the new court case, because this attempts to resolve multiple issues that is going on with this abuse.
Everybody, can you see how Wayne works? Isn't he fabulous? We love you, Wayne. You're brilliant.
Oh,
Absolutely brilliant. Take us to the implications of this new court case.
So there's three main issues to be decided. I first sent a pre-action protocol to the Lord Chancellor, who's responsible for the Ministry of Justice, and she never replied. Well, she did reply, but she treated it as a constituency request, which, first of all, it was a letter before claim. It was clearly identified as that with all the legal challenges. So there's no way she could think I was asking her for help as a constituent. And second of all, I'm not even a constituent. So why would she treat it as a constituent request when I'm not a constituent? Yeah. So she effectively ignored the pre-action protocol when she has a duty to respond to it. So then I issued proceedings. The Ministry of Justice failed to supply acknowledgement of service in time. Now, that means at this current moment in time, they don't have a defence.
Wow.
Now, they've applied for an extension of time. It's not been granted yet, so the High Court, they have a discretion to do what they want. It's not to do what they want, but what they think is in the interest of justice. So they can grant them the extension of time. It's not been granted yet, but it can be. And so at the moment, they don't have a defence. So when they did file their acknowledgement of service, this is what they said. And I'm just going to read it out because this is important to listen to, because normally a government will deny things black and blue. They'll say it's hopeless. It's got no merit. It's not arguable. All these sort of terminologies. But this is what they said. The defendant is content for the claim to proceed as a test case, provided all views can be effectively ventilated before the court. The defendant considers there is a public interest in resolving these issues raised by the claimant. Ever since the decision in Leighton versus Bristow and Sutter, there has been uncertainty as to what constitutes authority. In such circumstances, the defendant considers there is public interest in resolving these issues, and the case presents a valuable opportunity to provide authoritative guidance to other individuals in the positions of the claimants, as well as local councils and enforcement agencies. In particular, deciding these issues will help each of the foregoing groups understand their rights and obligations. So what they've admitted is that not only is this case of public interest, but that it creates a valuable opportunity for people to know their rights and for the councils and the enforcement agencies to know their obligations. So this is affecting many different, not
Absolutely.
just people across
Huge.
the country.
Yeah. This,
So yes,
I mean, it's the biggest test case of its kind, isn't it? Because what you're doing is you are testing the lawfulness of enforcement of council tax, right? And so, as you say, you're seeking to clarify 3 issues. So, what are those 3 issues that you're seeking to clarify?
Well, just before I go to the 3 issues, can I just elaborate on what I said?
Of course you can, Wayne. Absolutely, go for it.
I think this is a very important point. So, if the first part of what I just read out, they said that they wanted other views to be ventilated before the court. And what they mean in simple lay terms by that is they want help. They want other government departments to join them as a defendant, right? So what they did, the Ministry of Justice, they contacted 6 other government departments and organisations, and they asked them to join them as a defendant against me, right? So they wanted other people to help them. So the bodies they asked, they sent an invitation to us: the Ministry of Housing, Communities and Local Government, the Institute of Revenue and Ratings, the Local Government Association, the Civil Enforcement Association, the Enforcement Conduct Board, and the High Court Enforcement Officers Association.
Wow.
So they asked all these 6 different departments to join them as a defendant, and every one of them declined the invitation. So they're now left to fight this by themselves. Now, what I did last week was I also sent an invitation to the Ministry of Housing and Communities and Local Government to be a defendant, because some of the ways they've pleaded their defence have given me good grounds to say that now they need to come in on it. But they declined my invitation. Well, they didn't respond to my invitation, should I say. So I made an application under CPR 19 to make them a defendant without their consent. That's going to be decided by the High Court. They can refuse it, they can accept it, but the High Court will look at it. Look, the defendant and the claimant are both saying that this government department should join as the defendant. So it's likely there will become a defendant. There might not. Again, it's discretion of the High Court, but both me and the Ministry of Justice have invited them. Just because they've refused the invitation doesn't mean that they shouldn't join. So that's for the High Court to decide. So
I love this. You're holding them bang to rights. I mean, what you're doing is you are forcing them into a corner where they are failing to come out fighting. But also, this also to a degree implicates, for want of a better description, the Deputy Prime Minister, Angela Rayner, because she's the housing minister, right?
Well, yes, and you've made a very good point there, and that actually what you said there, that's direct links to what I'm going to come on to next, because the Ministry of Justice they've made 2 applications. I've said one about an extension of time, which I'll come back to in a minute, but the other application they've made is to change their name. So they want to change their name from the Ministry of Justice to the Secretary of State for Justice, right? Which the Secretary of State is she's the top leader for the Ministry of Justice, but they don't want the department because it's damaging to reputation. The Secretary of State comes and goes. The Ministry of Justice is always the same. But what is interesting is when the Ministry of Justice sent an invitation to the Ministry of Housing, Communities and Local Government, they didn't address it to the Secretary of State for the Ministry of Housing and Communities and Local Government, which you said is Angela. They addressed it to the department. So that's interesting, is that they're saying their name of the government department should change to the name of the minister, but their invitation wasn't to the minister, it was to the name of the government department.
They don't know what they're doing. They don't know what they're doing.
It's very interesting.
You caught them on the back foot. You've
So
got
that-
on the back foot,
that-
Wayne. This is the problem. Nobody does what you do generally, right? You've taken it this far. And that's the thing, is that they don't actually know how to come out fighting with you. They're like, okay, we'll get it changed from the name of the department, and we'll do it as Secretary of State, because obviously we don't want to have a bad reputation for this department. Ministry of Justice is already in trouble, people. I'm here to tell you. So Wayne, go on, carry on with us. Talk to us more.
Yeah, so just I'll when I finish on the 3 points, I just say to the on the 13th. So there's 3 applications for them to decide. One is obviously my application to make the Ministry of Housing, Communities and Local Government an extra defendant. The second is they're trying to change the name from the Ministry of Justice to the Secretary of State for Justice. Now the third one, this is the really interesting one. They've applied for an extension of time, right? So they've got no justification for the delay. Now, like I say, it's the court's discretion if they want to grant an extension of time, but they have to look at the reasons, and they've got no justifiable reasons for the delay. So that needs to be taken into consideration, that they have no excuse for the delay. Secondly, they never replied to the pre-action protocol, so they've had a long time to think of a defence. So they couldn't even comply with the acknowledgement of service, let alone the pre-action protocol. And thirdly is their defence for what they're saying is the source of authority, not the evidence, that the source of authority to come into your property and take your goods. I can show, like, not like 80%, like 100%, that is a false justification. It's not a source of authority. Now, I'm not saying they've lied with it. What I think's happened, in my genuine belief, is that the barrister's been misled by the enforcement agencies, because she's not specialist in this area. She is in human rights, but not in this particular niche of enforcement of council tax. So she's taken the enforcement agent's word and used this, and I can categorically show that defence is not a source in law to enter our properties. So the High Court now need to decide whether they grant them an extension of time when they haven't got a justification for the delay. They never replied to the pre-action protocol, and the defence actually is erroneous. So how they deal with that is going to be very interesting. So the 3 main points that this case is all about is, the first one we've discussed is, what is the source of authority to come into our premises and take our goods? That's the first question. The second is, what are the limits of the council's powers of delegation? Because this situation with the enforcement of council tax, it's not just the council enforcing it. They delegate their powers, and you can't just delegate willy-nilly. Not like handing lollipops out here, there, and everywhere. You've got to actually do it within their limits. And my case is they're not delegating it lawfully. So the second question is, what are the limits of local authorities' powers? And the third one is, it's questioning the lawfulness of council tax and administration enforcement regulations, the actual lawfulness of it, because my claim is it's not compatible with the European Convention to Human Rights because of the way it's been enforced. Not that they can't make it lawful, they can if they do it properly, but the way that it's administered is incompatible with the Human Convention to Court of Human Rights. So that I'm arguing that the actual regulations are unlawful themselves. So they're the 3 main issues that the court needs to determine.
Brilliant. I mean, this is exactly the kind of stuff that we want to hear, because we often hear, don't we? We're all frustrated. We're angry. We feel that we're being taken for a ride, but you're actually doing something about it. So let us be clear here, because our time, unfortunately, has come to an end today, and you've been a brilliant guest. Absolutely brilliant. But let us be clear here. Your next hearing is in London's High Court on the 13th of May, obviously this year, 2025. Where can people follow what you're doing, Wayne? Because you want people there. It's an open court, right? And you want people there to support you. Where can people follow what you're doing?
Well, what I've done is I thought about how to get this across most effectively, because I was going to give you an email, but it's getting very difficult if I get loads of requests. So what I've done is this weekend, I set up a Facebook group. So if anybody's interested in helping support to stop this abusive process and get behind what's going on, the group's called Stop the Abuse. It's a brand new group. There's no one in it yet. I've only just set it up. But if you join that group, you can help join the cause, support it. You can even ventilate your views and help express what's happened to you. You get the updates of all what's going on. So if you join the group called Stop the Abuse, you can get up-to-date information.
Please send me, will you email me a link so I can put it in the description? That will just make it much easier for everybody. Wayne, you are a people's hero. I am absolutely honoured to have had you on the show today. Thank you so much for just being so prepared to do this. You're literally doing God's work here, and I absolutely love it. Everybody, this is Wayne Leighton, and he is indeed a star. Take good care of yourself, Wayne. Lovely to have you with us this morning.
Have a nice day.
Thank you so much. You too, darling.
Bye.
Take good care. Brilliant work. Brilliant work. I love people working for the people.
It's time to wake up with Sonia Poulton.